Good morning, guys. Pro se litigants. I hope my child will allow me to read because he's awake now and my mom is still sleeping. So I'm gonna read that motion for reconsideration that I created within under 24 hours, and I filed it with the court. And your privilege here is because you're gonna hear it before opposing counsel. Now, my disclosures. This is how I wrote that. There is obviously maybe possibly a different standard. I'm a pro se. I don't claim myself to be an attorney either. But this is the step you do not want to miss, so they won't say something like, well, you would not let judge to reconsider if you felt that he was unfair. Again, I have a different background and different approach in the history, because that same judge was biased towards me in my previous case. So this is established pattern by the judge here, right? And yes, that's hard to show and prove judge bias. In addition to that, I have to say that opposing counsel, she had a weak case, and they all knew about that. In addition to that, they made some mistakes. One thing they did not know about the judge, because if the judge ruled in my favor, they already knew they would have to appeal it as well, and they would be appellant, I would be appellee. That's why they also hired a court reporter to make the transcripts, and in civil cases it's not required. If you're pro se and if you have some issues with judges, or you're not sure, you do want to order a court reporter, because civil cases are not required. Only criminal cases required court reporter. So there was an addition mistake to opposing counsel, because their case was not strong, and they thought they're gonna appeal if the judge would rule in my favor, and he's supposed to rule in my favor because I will read this to you, right? But that's something they could not even know the extent of judge bias. Okay, so they hired that reporter, and I ran after the hearing to meet her, and I said, who hired you? And she said, opposing counsel. So I exchanged information right there and then. This way I saved a lot of time. I already ordered my court scripts, and without having those scripts, if the opposing counsel didn't order that, I would not really have much to appeal. Okay, so I only had witness with me, but that was just not enough. So now with court records, it's going to be pretty much everything I say is going to be supported by the court record. And then again, I'm doing my motion for reconsideration. These are my disclosures. I'm not an attorney. I'm a pro se litigant here. Okay, this is what I see. This is the truth. This is how I see it. And I don't have to manipulate information, because it's nothing but the truth here, whereas the opposing counsel will. So my motion reconsideration is basically a transcript of what happened, right? And this is what the judge read already, because I showed up in the courtroom the next day to show him that I'm here, and there must be a reason why I'm there. So I'm sure he probably inquired why I was there. And then again, a privilege here, opposing counsel getting that envelope today. So you're gonna hear it firsthand. So let me start. In my motion for reconsideration, I'm also designed it in a way of an appeal option. So the judge will see some and recognize what is going to be going into the appeal. And honestly, I think he's in the hot seat right now just because he does not know. I don't know what he's going to do at this point. I just don't know. I don't know what I would even do at this point, but everything depends on his next move. Motion for reconsideration is filed so he can overlook the case, give him another hands up to reconsider, right, the decision that he already pre-made before that door opened, because he knew exactly who I was. He knows my name. He knows how I look like. I mean, that's very special treatment here for me from the judge. So comes now. Plaintiff submits its motion to Judge Rizek for decision reconsideration for the following reasons. Then I indicate my case timeline. The hearing was scheduled and held on July 14th, 2025. On May 30, 25, Centera Health Plan's defendant filed its special plea in bar. On May 31, 2025, plaintiff responded to defendant issuing a notice letter to correct, adjust, refile, or withdraw its special plea due to fraud upon the court and misrepresentation of Virginia Code 63.21509, and filed the same with the court on June 2nd, 25. On June 2nd, 25, defendant refused to act and make appropriate corrections to its special plea, which was also a due date to file its response. On June 6, 2025, plaintiff filed several motions to address fraud upon the court by the court. On June 10, 25, defendant acknowledged plaintiff's motions related to fraud upon the court and misrepresentation of Virginia Code 63.21509, and still did not act to make appropriate corrections to its special plea. Instead, defendant issued a mutually agreed hearing notice where the court should hear only the following: defendant's special plea, plaintiff notice letter, answer motion to strike defendant's special plea and exhibits, motion fraud upon the court, motion for recusal under substitution for cause, motion in limine, motion specified to strike defendant's special plea, and motion to prohibit defendant pleadings. On June 19, 2025, defendant finally filed its motion to amend its special plea and to amend the hearing notice with the court. On June 23, 25, plaintiff filed its opposition to defendant motion to amend its special plea and the hearing notice. On July 2, 2025, defendant filed its reply to plaintiff's motion to strike. And the last one is on July 3rd, 2025, plaintiff filed its opposition to defendant response to plaintiff motion to strike. So I am basically summarizing the whole filings in the case timeline so they can see the order, what happened after what. And now we're going into the whole body of this motion for reconsideration filed by me the next day. And the way I designed my motion, the way you would simply try to file for an appeal. The first one is assignment of error number 1, abuse of discretion number 1. Judicial impartiality is reasonably questioned. On July 14, 2025, the court, in the face of Honorable Judge Rizek, prematurely decided on the case to be dismissed for the following reasons. Plaintiff filed its motion for recusal under substitution for cause on June 6, 2025, before case was assigned to any judge, and as follows. Number 1, Judge Rizek heard plaintiff's case 4339 involving York DSS and erroneously dismissed this case in favor of York DSS in October 2024. This case is still pending with Virginia Court of Appeals to determine Judge Rizek's fairness or lack of impartiality under assignment error number 3. Number 2, Judge Rizek has a personal knowledge of the case 4339, parties involved, plaintiff, York DSS, Centera Health Plans, and familiar with some exhibits for that case. Furthermore, at the hearing on July 14, 2025, the judge remembered and expressed details of this case, including his ruling against plaintiff. Number 3, at appeal under assignment of error 3, plaintiff disclosed to Virginia Court of Appeals that Judge Rizek was not impartial towards her and in the case number 4339. Number 4, Judge Rizek is aware of this fact as well as because during the hearing on July 14, 2025, plaintiff never mentioned judicial bias in her motion for recusal to Judge Rizek. The reason for plaintiff's motion for recusal states as follows. Canons Rule 2.11a1. The judge has personal knowledge of facts that are in dispute in the proceeding. Furthermore, during the hearing, Judge Rizek even justified to plaintiff that he is not biased towards plaintiff and this canon rule does not apply to him, and denied plaintiff's motion for recusal. This is where, to confirm impartiality, Judge Rizek should follow canons and assign this case to another judge also available that day. Number 5, plaintiff asked clerk of the court several times to make sure Judge Rizek sees the motion for recusal during his independent case review prior to the hearing, and assigned the case to Judge D. Ford, who never heard the case number 4339 and who also was available on July 14, 2025 to hear plaintiff's case. Number 6, via plaintiff's answer to defendant's special plea during the hearing and before judge ruling on motion to recuse, plaintiff attempted to inform Judge Rizek that defendant made the judge partial by default to this hearing when claiming in its special plea the following: with no prior findings by the court, which is Judge Rizek, of bad faith or malicious intent, heavily relying on judge's favorable decision, which was further granted to defendant as expected by plaintiff. The fact that Judge Rizek had a chance to review the case before hearing and did not assign plaintiff's case to Judge DeFord, and even during the hearing refused to recuse himself from plaintiff's new case under Canons Rule 2.11a1, raises a question of Judge Rizek's impartiality and unfairness towards plaintiff and in favor for defendant. It may also indicate Judge Rizek's desire to assure that plaintiff's case gets dismissed regardless, consequently making all rulings in favor of defendant. Regardless, Judge Rizek wanted to hear this case and refused to recuse, indicating that decision was already pre-made before the hearing to dismiss plaintiff's motions and the case altogether without prejudice, which also raises a question of judge impartiality in this case as it was in case number 4339. Number 7. Plaintiff accepted Judge Rizek's decision to refuse recusal, hoping for judge fairness and impartiality in this case and regardless of what happened in the previous case, where his ruling was not in favor of plaintiff. However, this case proceeding was almost mirrored of previous case proceeding with exceptions. This time, Judge Rizek did not interrupt plaintiff and let her talk as long as needed, even showed somewhat patience or sympathy when plaintiff broke in tears reading and testifying to her own complaint. In addition, Judge Rizek dismissed plaintiff's case without prejudice instead of dismissing defendant's special plea of general issue, because this special plea in bar is nothing other than a special plea of general issue which is prohibited in Virginia. Assignment of error number 2. Abuse of discretion. Number 2. Court failed to address fraud upon itself. Court abuses discretion by not addressing fraud upon itself. Defendant clearly committed fraud upon the court in its special plea by claiming that plaintiff's child had a lack of adult supervision. Defendant also built its special plea on this specific claim. After plaintiff notified defendant to correct its special plea and provided time to do so, defendant refused to act. Based on fraud upon the court, specifically defendant's claim for child lack of adult supervision, plaintiff filed its 3 motions. During this hearing, the court should hear after motion for recusal the following: defendant's special plea, burden of proof, and plaintiff's motion, plaintiff responses. Instead, number 1, Judge Rizek decided to hear first defendant's motion to amend its special plea, personally argued from the bench on behalf of defendant with plaintiff over fraud upon the court versus opposing counsel's clerical error, and immediately granted defendant its motion to amend its special plea. This judicial action instantly stripped plaintiff of her defenses by annulling those motions, including fraud upon the court, that should be heard first at this hearing. Plaintiff motions were based on defendant's fraudulent claim and were filed before defendant's motion to amend. Granting defendant motion to amend its special plea stripped plaintiff of her defenses, impacted the hearing in its entirety, violating plaintiff constitutional fundamental rights under the 14th Amendment of Constitution, a right to fair trial. The same thing happened in the case 4339, which is currently with Virginia Court of Appeals, also indicating established mistreatment of plaintiff by the judge. Number 2, Judge Rizek also allowed defendant to retract its original claim, fraud upon the court, from special plea, downgrading such violation to clerical error by counsel. Virginia laws and Virginia Supreme Court rules do not allow to retract claims from original pleadings, especially if defense and opposition is built on those claims. Such action is not supported prompted by Virginia law or Virginia Supreme Court rules. Mom, я записываю. It also raises a question of Judge Rizik's partiality and unfairness to plaintiff. And number 3, defendant did not go over its special plea or bear its burden of proof paragraph by paragraph as required by law, but only verbally and unsworn pleaded its statutory immunity under Virginia Code 63.2-1509, whereas plaintiff was asked to read and testify over her original complaint paragraph by paragraph to bear her burden of proof of defendant's malice intent. To summarize, plaintiff's complaint was not a subject of this hearing, but defendant's special plea was. Assignment of error number 3, abuse of discretion. Discretion 3. The court abused its discretion by not dismissing defendant's special plea in bar, which evidently was a special plea of general issue. In Virginia, special plea of general issue is prohibited since 2006. It was brought by plaintiff and ignored by the judge. In Virginia, special plea presents external facts that act as complete defense regardless of the merits of the claim. Number 2. Defendant failed claiming its special plea in bar by referencing to plaintiff's complaint throughout its special plea, instead of pleading under special plea requirements or external facts such as statute of limitation, statute of frauds, res judicata, or lack of proper parties. This was brought by plaintiff too and ignored by Judge Rizik. Number 3, defendant suddenly claimed its statutory immunity under Virginia Code 63.2-1509 as the hearing proceeded, which was also misrepresented by defendant in its special plea. This was also brought by plaintiff too and ignored by Judge Rizik. Number 4, regardless what plaintiff had to share, what Virginia Code 63.2-1509 says, including certain injuries to the child, Judge Rizik did not address. Furthermore, the judge ordered plaintiff to talk about malice intent facts and asked plaintiff to read paragraphs of the original complaint, which should not be even looked at during this hearing, considering the merits of the case or the original hearing notice. Number 5, in addition, it took plaintiff about 15 to 20 minutes or more to go over the original complaint, establishing facts of malice intent, where Judge Rizik showed a lot of patience and did not interrupt. The judge should also allow defendant to argue each paragraph read by plaintiff and then make its ruling based on those arguments. However, as soon as plaintiff finished with the complaint, it took less than 1 minute for the judge to sustain defendant's special plea. The judge would require more time to process all the information carefully, maybe even call for hearing intermission to serve a deliberated and fair ruling, but it did not happen either, indicating that Judge Rizik already decided on the case to dismiss it prior to the hearing. Number 6, defendant should be defending its special plea with burden of proof paragraph by paragraph, but during the hearing it was plaintiff who testified in attempt to defend its original complaint, which should not be even heard due to defendant's special plea pleading and outside of the original hearing notice. Next, assignment of error number 4, error of law. Number 1, defendant in this case misrepresented Virginia Code 63.2-1509 by claiming its statutory immunity in its special plea. Number 2, this specific Virginia Code does not provide statutory immunity to defendant under circumstances of this defamation case. Number 3, plaintiff filed this law with the court under index to assure that the court has it on file on July 3, 2025. Number 4, defendant should be arguing its special plea statutory immunity under Virginia Code 63.2-1509 with plaintiff before Judge Rizik. Number 5, instead, Judge Rizik took a side of defendant and personally got himself involved into argument discussion with plaintiff over this Virginia Code. Number 6, Plaintiff told Judge Rizek that defendant cannot claim its statutory immunity under this code. Per this code, mandated child abuse reporters can claim its statutory immunity if A. certain injuries to children be reported by, that's Virginia Code 63.2-1509, and the name of that code, certain injuries to children to be reported, that's the name of that law. In this case, plaintiff child did not suffer any or certain injuries provided by that law. B. reason to suspect that a child is abused or neglected shall due to the special medical needs of infants affected by substance exposure. Now, I'm quoting this code, right? In this case, plaintiff child is not infant, did not have any or special medical needs of substance exposure provided by this law. C. No person shall be required to make a report pursuant to this section if the person has actual knowledge that the same matter has been already reported. In this case, defendant had a personal knowledge on different subject matter, poverty, not child abuse or neglect, and reported it anyway, indicated malice, intent, or reckless disregard to the truth. D. During argument that should be between defendant and plaintiff, but instead was between Judge Rizek on behalf of defendant and against plaintiff, the judge brought to the argument malice, intent of defendant, not mentioned anywhere under Virginia Code 63.2-1509. E. Judge Rizek also asked plaintiff to prove defendant's malice intent by offering time to read plaintiff's original complaint, which should not be heard in this hearing due to the special plea, instead of offering time to defendant to bear its special plea burden of proof. F. Judge Rizek listened to plaintiff arguments without interruptions, this time in reference to the case 4339, currently pending with Virginia Court of Appeals, but he also argued this matter with plaintiff on behalf of defendant, which indicates judge's inability to remain impartial and clear bias towards plaintiff that consequently led to the case dismissal. 7. Defendant filed a special plea in bar which clearly and evidentially addresses merits of plaintiff's original complaint, also was addressed by plaintiff to the judge, and therefore it's a special plea of general issue, which is also prohibited in Virginia. Judge Rizek should instantly dismiss the special plea and order defendant to answer plaintiff's complaint. Instead, he sustained defendant's special plea, which conflicts with Virginia law. Now, assignment of error number 5, procedural issues and violations. Number 1, Judge Rizek should hear only defendant's special plea and plaintiff's motions filed thereafter, as it was indicated original hearing notice upon parties' mutual agreement filed with the court on June 10, 2025. Number 2, for that specific reason, Judge Rizek had to administer the oath to all defendant, plaintiff, court reporter, and witnesses present in the courtroom before the hearing started. This also did not happen to ensure the integrity of the hearing and the fairness of the trial, which is a procedural violation pursuant to Rule 603, oath or affirmation to testify truthfully. Failure to administer oath to defendant, special plea, burden of proof, and plaintiff complaint malice facts makes this hearing invalid in the face of law. Number 3, Judge Rizek first heard defendant's motion to amend its special plea instead of hearing defendant's original special plea itself, and to be followed by plaintiff's motions. This specific hearing proceeding arrangement, led directly by the judge, is outside the filing timeline order and clearly was done in favor of defendant. This is why I indicated the case timeline in the beginning. Number 4, specifically, Judge Rizek first granted defendant its motion to amend its special plea before hearing plaintiff's motions, including motion fraud upon the court and motions to strike, which were also filed before defendant's motion to amend. By doing so, the judge annulled plaintiff's motions and stripped plaintiff of its defenses in favor of defendant to ensure unfair trial to plaintiff, which is also a violation of plaintiff's constitutional rights under right to fair due process. Number 5. Judge Rizek failed to address fraud upon itself, ruling that defendant's fraudulent special plea claim, child without adult supervision, was a clerical error by opposing counsel. Any arguments raised by plaintiff before or after the ruling in reference to fraud upon the court were ignored by the judge. Specifically, instead of remaining impartial and allow defendant and plaintiff arguing on fraud upon the court issue, Judge Rizek, on behalf of defendant, argued directly himself from the bench with plaintiff on the same matter, indicating on judicial impartiality, judicial bias, pre-hearing and pre-judge decision in favor of defendant. Number 6. Judge Rizek allowed defendant to retract its special plea original claim and downgraded it to counsel's clerical error. It was not spelling or clerical error. It was a special pleas defense claim. Exhibit was provided to defendant and to the court. In Virginia, no party is permitted to withdraw or change its original pleading claims. In this case, the judge not only ignored plaintiff arguments, but also permitted defendant to change pleading, which is prohibited by Virginia law or Virginia Supreme Court rules. Number 7. Judge Rizek should address plaintiff's motion fraud upon the court and address it first. Due to procedural discrepancies, this hearing manifests Judge Rizek's unfairness towards plaintiff. Number 8. To ensure a fair hearing, the Judge Rizek should not hear this case under Canon 2.11a1 and assign this case to different judge, or to grant plaintiff its motion for recusal and stop the hearing proceeding. Instead, Judge Rizek did not assign this case to another judge who was also available on July 14th and refused to recuse himself during the hearing, also indicating judge's specific desire to hear the case, which he decided in favor of defendant as it was in previous plaintiff's case. It also raises a question of judicial bias towards plaintiff's second time around, because I had 2 cases with that same judge. So there is a pattern. Number 2. To ensure a fair hearing, Judge Rizek should address fraud upon itself, dismiss defendant's special plea of general issue, and to either prohibit defendant from further pleading requested by plaintiff, or order defendant to respond to plaintiff's original complaint and reschedule the hearing. This did not happen. Number 10. Judge Rizek engaged himself into argument on behalf of defendant over Virginia Code 63.21509 instead of remain impartial. 11. Judge Rizek made plaintiff to go over its original complaint that was not listed in the original hearing notice and was not the subject for this hearing. 12. Plaintiff files this motion for reconsideration to ensure that Judge Rizek has an opportunity to preview and address all issues of this case fairly and without prejudice before the case goes to Virginia Court of Appeals. 13. For the appeal action purposes, to confirm judicial bias towards plaintiff in this case and outside of this case, Judge Rizek will deny or dismiss this motion for reconsideration. That means I already know. I just don't know what he's gonna do. But to confirm his impartiality, he will deny this motion, right? 14. For the appeal action purpose, to ensure the fairness or due process to plaintiff, a new hearing is requested by impartial judge and in different jurisdiction, excluding Yorktown and Virginia Beach, or to be heard de novo by Virginia Court of Appeals. To summarize, the way this hearing went on, the opposing counsel's attendance was not even required because most legal arguments raised during the hearing were between plaintiff and the judge instead of between plaintiff and defendant. Note, there is a possibility of other issues of this hearing to be available upon hearing transcript records, including Judge Rizek's failure to order defendant to provide relevant exhibits in support of its special plea. That would be phone audio records of plaintiff and defendant, as well as documented supervisor case manager notes in reference to defendant's malice intent and false allegations of child abuse and neglect against plaintiff, required for the hearing, further to be supported by official court transcript. Because now I have that too. And I told you why. Because the opposing counsel, she thought, the way the judge should rule, he should rule in my favor. She could not ever guess that the judge was biased and did the all work for her. So that's why she hired a court reporter, so they can have some documentation to fight at the appeal level. But there was a mistake, because now I have access to that. Okay, so, and this is, everything is going to go to Court of Appeals, and I only hope that it's not a corrupted court. I only hope so. Conclusion. Wherefore, plaintiff submits its motion for reconsideration with the court and asks Judge Rizek to fairly review the case and address all issues listed herein, including but not limited to motion for recusal, motion fraud upon the court, motion to strike and dismiss defendant's special plea of general issue prohibited in the state of Virginia. In addition, plaintiff has strong reasons to believe that this motion will be denied and or dismissed due to judicial bias openly manifested throughout this case. Furthermore, when judge openly takes the side of one party during trial, the other party has no chance to fair trial or to fair judgment. In addition, Judge Rizek's failure to administer the oath to all parties involved before testimonies make this hearing invalid. Finally, plaintiff is asking this court to cover the expense for the court transcript cost associated with invalid hearing that took place on July 14, 2025, required for plaintiff's further appeal action. And then, of course, because I'm pro se and because I'm bilingual, I put another note. Please excuse grammatical and spelling errors, as this motion for reconsideration was written under 24 hours from the time of the hearing. It was dated July 15, 2025. So again, this was provided to the judge. Later on today, opposing counsel will get that. I already ordered court transcripts. This is what you need to have. If you have a judge like that, you know, in a civil case, pro se can only do civil case, you do want to get those court records. Again, because my case was very strong, attorney also contributed to weaken their case by making some mistakes like fraud upon the court. They thought the judge is normal and the judge probably will rule in my favor, and that's the only reason why they filed a court reporter. If they wouldn't, I would be pretty screwed. But now I have the court record too, because opposing counsel ordered that. Ordered it for herself, but turned out to be actually ordered it for me, right? So it's about 33 minutes. I hope that will give you some ideas what actually happened during the trial. And then when I put my appeal brief, I will pretty much transfer all of that into that, and then I have to do a lot of citations to the record once I get the script, and I have to find some legal cases to support that. Again, I am a pro se litigant, and I'm hoping the court will look into that as well. But it is what it is. So I don't know really what the judge will do. I mean, one option would be for him to just recuse. That would be reasonable to do. Recuse this case and start a new hearing and keep it at the level of circuit court and not allow it, because why he did prejudice, I'm sorry, without prejudice, so I can file it back again. It would come back again to him and would bounce back. And then now the opposing counsel has to respond to that motion as well. And then I have a last word to say to close it. I'm not even going to do that, because I already know. He is going to probably deny. She's going to respond. I don't need to respond anymore. This was only to tell the judge that I already know. I did what I could. I notified him. If he does not change any of his rulings or doesn't play a different card, like let's say motion recusal, give it to another judge, then it's going straight to appeals. So I hope that was helpful, but again, I don't think you see that many people reading their documents. Again, I'm a pro se, I'm not an attorney, but you can see some things maybe that will help you in the future. Again, the judges are pretty often not fair to pro se litigants because we don't really belong to that circle. So, and that judge did not know opposing counsel whatsoever, but yet he still would take her side. Okay, so talk to you soon.